Welcome to The Point of View. This is your favorite current affairs show on Channel One television. On The Point of View, we get the right topics, get the right guests, and ask them relevant questions on issues that matter to you. We have a very interesting show for you tonight because the economy has been a big discussion for the past 3 years. This election, we are told as well, that the economy will be one of the key issues voters look at. Tonight, I'm speaking to a man who has decided to not only sue the government and in terms of making specific requests of the courts, but is also seeking an injunction to restrain the government from undertaking any further domestic borrowing until a very important matter is heard. We'll be speaking to this lawyer when we come back on this matter. Stay with us. Welcome back. So tonight we're back on the economy and finance because a very big topic, and the angle is more legal than anything. A lawyer, Jonathan Amable, has gone to the Supreme Court. Indeed, he has two issues. In February, he went to the Supreme Court to ask for interpretation of whether the government, treasury bills, treasury bonds, and some of its domestic financing activities constituted loans that required prior parliamentary approval, because as things stand now, those issues do not get prior parliamentary approval explicitly before the government undertakes the borrowing. That matter has not yet been determined. Now, Mr. Mable has gone back to the Supreme Court to say, you know what? If government borrows any further money from the domestic market, whether it's a bond market or the treasury bill market, the consequences would be grave for the economy and our future. And therefore, the court should grant an order of what the lawyers call interlocutory injunction to restrain the state from undertaking any activity which constitutes borrowing, or what economists call debt financing, including raising debt finance through temporary advances and other loans from the Bank of Ghana, or the issuance of treasury bills. Now, treasury bills and treasury bonds have been the main way government has been raising money since the domestic debt exchange. We know that government, basically, what does it do? You raise revenue to take care of your expenditures. If you can't raise enough tax revenue, what do? You borrow. And this borrowing takes the form of external borrowing or domestic borrowing. And the treasury bonds and treasury bills have become the mainstay of government since the economic crisis of July to December 2022. So Jonathan K. Amable is a private legal practitioner. Jonathan, welcome to the show.
Thank you, Bernard. Thank you for having me and for the interest you've shown in the matter.
Wonderful. So a lawyer who is taking on a serious economics and finance issue, just give me an insight into your interest in this issue of government borrowing and how that interest led you to go as far as the Supreme Court in February to seek interpretation of some key issues.
Thank you. So I'm a finance lawyer.
Okay.
So finance is what I specialize in. So I smiled when you said it's more of a legal issue than economic issue, because the two are actually intertwined.
Wonderful.
The kind of work that I do mostly is public finance, corporate finance. So I advise the government if it wants in relation to domestic or even foreign debt issuances. I advise corporates on the market. I advise even the regulators, so the SEC, the Ghana Stock Exchange, Bank of Ghana. So this field is a field that I've been practicing in for several years now, and so some of the matters are matters that I know quite intimately, and especially on the back of the domestic debt exchange program that has just happened, and the domestic debt restructuring program, that the painful exercise that has just been undertaken. I realized that there's a certain loophole that needs to be closed, and when that loophole is closed, it would give some reprieve to Ghanaians in terms of how some of these things would come about, and that really necessitated my action to go to the Supreme Court, not for an interpretation, because under Article 2 of the Constitution, the Supreme Court has two jurisdictions. There's an interpretative jurisdiction and there's an enforcement jurisdiction.
Wonderful.
So the interpretation jurisdiction means that something is unclear and you're asking the Supreme Court, so we normally use the words a true and proper interpretation of so and so. So there's that. And then there's also the general enforcement jurisdiction, where the Constitution says that if there's an act that has been done either by Parliament or by the executive or any person which contravenes the Constitution, you bring that action to the Supreme Court for that action to be declared unconstitutional, null and void. And if you ask for consequential orders, then consequential orders will be given. So that was the February suit that
So the February
filed.
suit was to declare unconstitutional what specifically?
So the February suit was attacking legislation, pieces of legislation, statutes.
Okay.
So Section 30 of the Bank of Ghana Act, which enables the Bank of Ghana to extend loans to the government. This is either through the Bank of Ghana directly purchasing T-bills from the government, or the Bank of Ghana purchasing bonds from the government, or the Bank of Ghana giving advances, temporary advances. So Section 30 enables the Bank of Ghana to lend to the government. And then Section 61 of the Public Financial Management Act also enables the government to borrow money through the issuance of T-bills. So through the issuance of T-bills, through the issuance of treasury notes, treasury bonds, basically domestic debt securities. Section 61 of the Public Financial Management Act enables the government to do these things. Now, when you look at the constitutional framework under Article 181, Article 181, 3 and 4 generally govern how the government should borrow. Now, I mean, it's tried learning in legal terms that borrowing is not a right. Borrowing is a power. The power is given to you by statute, or is given to you by, even a company, the power is given to the directors by the Constitution. And so that statute or Constitution can place limits on how the borrowing power is exercised.
Okay.
Now, in relation to the government of Ghana, Article 181 is clear that government should borrow under a statute, and the statute should state that the borrowing would not become effective unless the terms and conditions of the borrowing are laid before Parliament for approval. So it's very clear. It says that the borrowing should not become effective unless the terms are laid before Parliament for approval. And then Article 181.6 goes further to define borrowing or define loans for the purpose of Article 181. And you will see the Constitution is very interesting. In several instances, the Constitution uses words. It never bothers to define them. There's a general definition part of the Constitution, but you realize that for the purpose of Article 181, the Constitution is very specific. And I know that you've opened
So
it.
maybe let's read it, all right? So we're trying to sort of get the sense of the basis for the action. Don't forget, he's saying there are specific statutes and laws that contravene this Article 181. And by the way, because this is Constitution, this is higher.
Yes.
So anything in law that in Ghana that goes against this one is the superior law.
Exactly.
181, loans. Parliament, this is 181. Parliament may, by resolution supported by the votes of a majority of all members of Parliament, authorize the government to enter into an agreement for the granting of a loan out of any public fund or public account. 2, an agreement entered upon under clause 1 that I just read of this article shall be laid before Parliament and shall, the word is shall, and shall not come into operation unless it is approved by a resolution of Parliament. 3, no loan shall be raised by the government on behalf of itself or any other public institution or authority otherwise than or under the authority of an act of Parliament. So it's like reinforcing this. 4, an act of Parliament enacted in accordance with the clause 3 that I just read shall provide A, that the terms and conditions of the loan shall be laid before Parliament and shall not come into operation unless they have been approved by a resolution of Parliament, and B, that any money received in respect of that loan shall be paid into a consolidated fund and form part of the fund or into some other public fund of Ghana existing either or created for the purpose of the loan. Then let me end with 5. This article shall, with the necessary modifications by Parliament, apply to an international business or economic transaction to which the government is party as it applies to a loan.
Can you just add 6? Yes.
For the purposes of this article, loan, into quotes, includes any monies lent or given to or by government on condition of return or repayment, and any other forms of borrowing or lending in respect of which A, monies from the consolidated fund or any public fund may be used for payment or repayment, or B, monies from any fund by whatever name called established for the purpose of payment or repayment, whether directly or indirectly, may be used for payment or repayment. And then 7, the ministry responsible for finance shall, at such times as Parliament may determine, present to Parliament any information concerning any discrepancies relating to the granting of loans, their repayment and servicing, the payment into a consolidated fund or other public fund of money derived from loans raised on institutions outside Ghana. Why did you ask me to read 6?
Great. So let me just put 181 in context.
Yeah.
181 actually governs 3 types of transactions. If you look at 1 and 2, they govern situations where the government is the lending party. So the government is giving a loan to someone.
Good.
Then 3 and 4 deal with situations where the government is the borrowing party or borrowing on behalf of another institution.
Wonderful.
So 3 and 4 deal with the situation where typically the government will be the borrower.
Yeah.
And that is what is in contemplation.
So you are dealing with government borrowing. So this is 181, 3 and 4. That's what we are dealing with.
Great. Then 5 deals with international business and economic transactions.
Wonderful.
And Ghanaians have a history with that because if you will recall, the case involving Alfred Woyome, it had to do with 1815, where the claim was that the contract with Alfred Woyome was, and Waterville, was an international business and economic transaction. So on the basis that it did not have parliamentary approval, it was void. And the Supreme Court declared it void, and on the basis of that, the state went after Woyome to try and reclaim the monies that he had got from that contract. Because the principle in relation to 181 is that you cannot derive any benefit from an unconstitutional contract. You see that 3 and 4 are very clear that the borrowing shall not come into effect until parliamentary approval is obtained.
So 5 deals with international transactions.
Exactly. So 6 really explains what the Constitution means when it's looking at
a loan.
And it's very clear. If there is a situation where the government has taken money on condition of repayment, and you see that there are words where it says any other kind of borrowing where the money will be repaid out of the consolidated fund or any other public fund. So 1816 is very clear. And we say something that before you try to remove a fence, you need to find out why it is there. Article 181, its antecedents can be traced all the way to the 1969 Constitution.
Is it?
So when you look at Ghana's history, our economic history, you realize that I think our first debt restructuring exercise was actually in 1966. So on the back of that, when the 1968 proposal was being prepared, and a funny side note, the proposals were prepared by Nana Akufo-Addo's father. So the president, his father was more or less the chair of the committee that prepared those proposals.
Wow.
When you look at the relevant part, and I've given that to your producer, if it can be displayed so that everybody can take a look at it. They say that when you look at our state after 1966, Ghana was in a sorry state because there had been reckless borrowing and lending
under the Nkrumah
government. So in order to put a check to that, we needed to have some sort of financial control regime where the government's ability to lend money and its ability to borrow money would be regulated by an arm of government.
Which is the National Assembly.
And in that 1969 Constitution was the National Assembly.
Which is the Parliament.
Which is the Parliament of Ghana. So part of the checks and balances role that Parliament of Ghana is supposed to play is that they are supposed to approve the terms and conditions of all borrowings to the extent that that transaction is going to raise the public debt of Ghana.
Let me read the 589 of that senior Akufo-Addo document. You call it perversion of constitutional financial control regime loans. There's an emphasis part. It says, we propose that government should not enter into an agreement for the granting of loans out of any public fund or public account unless the National Assembly has approved by the vote of not less than 2/3 of the members of the Assembly the granting of loans. So you're thinking that this 92 Constitution, this Article 181, takes inspiration from?
It is a direct descendant.
Wonderful.
From 1968 proposals, we then had the provision in the 1969 Constitution.
Wonderful.
Then we had the same in the 1979 Constitution, and we have it in the 1992 Constitution.
And when you go to 590 of the same document, it says, further propose that the agreement entered into respect of the loan should be laid before the National Assembly and should not become effective or operative unless it has been approved by an ordinary resolution. So it's basically, they just borrow the words and just change a few things. And then government should not have power to raise a loan on behalf of itself or any public institution, this is 591, or authority except by or under the authority of an act of parliament. That act of parliament shall incorporate our above proposals regarding resolutions of the National Assembly mutatis mutandis.
That's correct. So when you look at this, you realize if you go back to 589, you realize that the reference was in relation to external debts.
Yes.
Because that most of our instances of debt restructuring prior to now has been with our external debt.
Yes.
And so this provision was proposed and it was meant to check that. Now, for the first time in 2022, we had a debt problem, and you will see that not only have we had to restructure our external debts, where we'd also had to restructure our domestic debt.
Yes.
So really, this is what set me thinking. And I went back to the basics. I went back to the Constitution. I was doing my research, and I looked at 1968, and I realized, wait a minute. When government is raising external loans, if it's external, bilateral, or multilateral, they are laid before Parliament. If it's external through the capital markets, that's the Eurobonds, they are still laid before Parliament. Now, what do we have in relation to the domestic setting? In the domestic setting, despite the clear terms of Article 181, we have, through these various statutes, the Bank of Ghana Act and the Public Financial Management Act, created a regime where for domestic debt and domestic borrowing, whether it's treasury bills, whether it's bonds, whether it's notes, there is no recourse to Parliament. Parliament does not approve anything. And that's really, when you look at it, and you know, I've prepared a presentation which basically talks about Ghana, a nation in crisis. How did we get here, and what is there to fear? When you look at that presentation, I've presented some data on how our domestic debt, in fact, how our broad debt, our gross public debt has grown over the years.
Let's look at that. I have a few charts here as you make the case. So basically, there's something you title Central Government Debt Stock, all right? Where the total debt is 761 billion as of 2024 September.
Yes.
Now, it starts from 122 billion in 2016, and it's grown to 761 billion. The domestic component is 290, and the external is 470.
470.
All right. Then we come to the domestic breakdown. The domestic grew from 53 in 2016, 66 in 2017, 193 2021, 206 2022, 290 in 2024. So it's your argument that what? The domestic debt component is becoming more and more important.
The domestic debt has become more and more important. And if you look at even the IMF reviews, you see that they've flagged it, that domestic debt and payment of interest in relation to domestic debt has become a significant portion of our expenses. It's eating up all our revenue. And when you look at the data here, I mean, it's quite clear. From 53 billion in 2016 to a situation where we have 290 billion as of 2024. We are currently in a dispensation where every week the Bank of Ghana and the Ministry of Finance are trying to raise as much as 4 billion, 5 billion, 6 billion.
Every week?
Every week.
4 billion cedis a week.
Last week, they were trying to raise 6.8 billion. And you see, sometimes I also have a...
Through T-bills?
Through T-bills alone. Last week, they were trying to raise 6.8 billion. The week before that, they were trying to raise 6.2 billion. So we don't really hear the figures in the media. All you hear is, oh, government T-bills have been undersubscribed. But what does that undersubscription mean?
Government actually wanted more.
They wanted more, and they've got more, because prior to that, they were maybe taking 4 billion, they were raising 4 billion, and all these huge figures have only come up since about 2022 even, because before 2022, the portion of T-bills was quite low.
Let me look at the central government domestic debt stock breakdown for that you gave. So again, 2016, so you have short-term, medium-term, long-term, non-marketable and standard tools. My knowledge of this is that treasury bills are under the short-term.
That's correct.
So that's either 91 day or basically 3 months,
yes,
6 months or 1 year. So that's short-term. Now, if I look at 2024, short-term is 94.7 billion, medium is 127.4 billion, long-term 67 billion. So short-term and medium-term are the largest chunk. Now, what is the state of play now? Does government go to Parliament to approve any of these? I have short-term, medium, long, non-marketable standard. Does the Finance Ministry and Bank of Ghana, do they go to Parliament for approval of any of these components?
So they go to Parliament to approve the last component, standard loans. And you can look at how minuscule that is
1.2
in relation
out
to
of
the
the
total
290.
debt stock.
So non-marketable, they don't go to Parliament?
They typically don't, because the non-marketable is mostly placed with the Bank of Ghana.
Long-term, they don't? Long-term domestic, that they don't?
Yes, so those are the normal treasury bonds.
They don't?
They don't go to the Parliament for approval.
Medium-term, they don't?
That's the notes. They don't go
and
to Parliament for approval. And the
T-bills, which is now the mainstay of government financing?
Yes, they don't. So through the statutory framework, they've basically excluded, when you look at our debt category for domestic debt, they've excluded the portion which makes up the significant chunk of our debt from parliamentary control. Where you have a situation where you have 290 billion, and only 1.2 billion out of that goes to Parliament for approval. you have a problem, because this is the institution that is supposed to be a check on government borrowing. And they are seeing less than 1% of the government's borrowing activity. The only way they hear about it is as a done deal. The thing has happened, and then they hear about it.
This is the point of view. My guest is a lawyer who says government domestic financing needs to get parliamentary approval. He took the matter to court in February this year. Somehow the matter hasn't really gotten a hearing. So now he's asking for an injunction for any further borrowing. So essentially, government should not be able to raise a peso starting when the matter will be heard. He filed 11th November until the substantive matter is determined. Now, what are the implications of that for government financing 2 weeks to an election? We'll be right back. Stay with us. Welcome back. So the point of view tonight is talking to a lawyer who is really saying the Bank of Ghana and Ministry of Finance have been perpetrating an illegality on Ghanaians by dealing in treasury bills, treasury bonds, domestic non-marketable securities without parliamentary approval. Jonathan Mable's thinks the Supreme Court should place an injunction on all further government lending, or borrowing from the domestic market until this matter is determined. Now, a couple of points here. The debt exchange that took place starting 2022 and 2023 seemed to affect all categories of lending to government except treasury bills. So, for example, there was an external debt restructuring. For Eurobonds alone, government said it saved 13 billion. Then there's the multilateral and bilateral loans, which I think they said they saved 5 billion. All this is dollars. And then we're told that they saved around 12 billion in domestic debt exchange. So people who took bonds with government had to take either a haircut in terms of tenor or the interest. But T-bills were not touched. So T-bills seem to be still safe and non-problematic. Now, if your argument is that the government's approach to financing, as evidenced by the way it handled domestic exchange, is a problem, somebody could say, well, T-bills, they pay. So there's no problem with T-bills. Even through the most difficult economic period in our past 20 years, T-bills are still getting payment. So why are you asking for even T-bills to be stopped until your original matter is determined?
Right. So if you look at the data again, if you look at the domestic debt stock breakdown, when you look at the portion of government debt that was in respect of T-bills as at 2022, when the DDP happened, you will see that T-bills was at 34 billion. Okay? You look at medium term, you see medium term was at 123 billion. Long term was at
20.2.
Yes. Long term was at 20.2 billion. Okay, that was 2022 then. If you look at where we stand today in 2024, short term was 94 billion. As
so times 3.
Yes.
34 in 2022 to 94.
Yes. Medium term has stayed at where it was, around, it was 123, it's just gone about 127. So you see that significantly T-bills are creeping up. And the reason why T-bills were excluded from the previous DDEP has nothing to do with the nature of instruments or whether it qualifies as borrowing and that it should be regulated under Article 181. If you go back to the chart that are provided on other key statistics, really, when you look at the key statistics, it tells you what the real problem is. You look at total revenue and grants, you look at expenditure, you look at GDP, you look at debt to GDP. And those are where the problems are coming from. If you look at 2024, for example, total revenue is projected at 176 billion, but we are intending to spend 238 billion. If you look at 2016, total revenue was 33 billion, and we're going to spend 51 billion.
So the deficit is getting bigger.
The deficit is growing, and as the deficit grows, there is a need to finance that deficit. The financing of the deficit can either take place through these T-bills or bonds or whatever, and the government is choosing to use T-bills to finance the deficit. So now, when we have a situation, and you look at the figures on the debt to GDP ratio, you realize that as we grow and this borrowing keeps getting out of hand, the debt to GDP ratio will continue to grow, and it will get to a point where we have to do another domestic debt exchange restructuring.
So
and
you
when
think
that
the
happens,
T-bills will get out of control?
When that happens, I guarantee you it's going to be very difficult for the government to exclude T-bills. Now, let me tell you, as it's public knowledge that in the DDEP that was just done, the only instruments that were really excluded were the multilaterals, because the multilaterals is where institutions like the World Bank and the IMF and co lend, and they excluded that from the debt perimeter. Everybody else was supposed to be touched. The Bank of Ghana was touched, and all the domestic, debt securities were touched, except the T-bills. Like I'm saying, it was really because if you did that,
there'll be no other source of money.
There'll be no other source of money. So that was, but when you look at, and the chart, you see other figures in relation to our upcoming obligations. When you look at our upcoming obligations in respect of the DDP, the rescheduled debt, we have massive payments that are coming up in 2027, 2028. When you look at the Eurobonds, there are coupon payments, default interest payments, and things that are starting as early as January 2025. And there is absolutely nowhere that the money is coming from, because the international capital markets are close to us. So if we continue borrowing in this way, there's absolutely nowhere.
Just a quick retort. So what I know is that treasury bills and treasury bonds are part of what we are told is open market operations. And the point around that is not just financing of deficit, but also to control inflation, basically using money supply to manage inflationary pressures. So the government uses those when they feel like the currency or there's too much inflation, they can use the selling of these bonds to reduce the interest rate so that things will come down on the inflation side. So my point is that if you ask that Parliament should essentially control this, aren't you tying the hands of the Bank of Ghana from doing its open market operations, which are not just financing issues, but also they go to the heart of inflation targeting and overall economic management?
Great.
I mean, are you
no, this is something that I think we must really get to the bottom of, because treasury bills really is about the government borrowing. Treasury bills are about financing the deficits of the government's budget. The open market operations, really, Bank of Ghana, which is, and Bank of Ghana's core duty is price stability and things like that. The instrument that they typically use for those operations are the OMO bills.
Yes.
So Bank of Ghana
that
has
goes
its
to commercial
own,
banks.
Yes, so it has its own bills.
Institutions.
So and I think this thing is something that is a perception that's quite out there. The Bank of Ghana has its own bills. Bank of Ghana's bills, I think the 56-day bill and some other bill that they use for their OMO operations. So the T-bills really
are not part of
They are not part of it.
Okay.
The money that comes from the T-bills are going either to the government as new financing, or the government is using it to repay debt which is maturing. Previously, the T-bills were used to mature expiring treasury bills. This year, because and since DDP, because other sources of borrowing have been closed to us, government of Ghana has been using T-bills to mature expiring other debt or any other obligation. So if there are some interest payments coming up on some bonds, the government will start ramping up T-bills to get money to pay those obligations. Now, what we should also never forget is that T-bills, because they are a function of the market, they're a function of demand and supply, there's always the risk that the government will go to the market and the market will refuse to lend, or the market will be quoting very high rates. We were in this country when the market was quoting 30% and the government said, we'll not borrow because it's too high. Later on, the government was forced to borrow. Now, when you look at the Bank of Ghana's statement on what led to its losses in 2022, you will realize that the Bank of Ghana cites that there were auction failures. Auction failures means that they were going to do T-bills and the primary dealers and the market were refusing to lend. And that created a requirement for the Bank of Ghana to now step in and lend the money to the government. When you look at the IMF is very, very clear that the Bank of Ghana's monetary financing of the budget led to the inflationary pressures that we saw in 2022. So there's a direct correlation. If we fail to put in place measures to prevent the government from borrowing, the market itself will step in. When the market feels like the government is borrowing too much, there's a high risk, and the market will refuse to lend.
So you went to court in February to ask that the Supreme Court should declare that treasury bills and treasury bonds are loans and therefore require parliamentary approval. What has happened to that case?
Great. So we went to the Supreme Court, like I was saying earlier, on a constitutional enforcement jurisdiction to ask the Supreme Court to declare those relevant provisions of the Bank of Ghana Act and the Public Financial Management Act unconstitutional. That was filed all the way in February. Now, that case, like I'm saying, is an enforcement matter because really, whether T-bills and domestic debt securities constitute borrowing, Article 1816 is very clear on it. And not just Article 1816. There's a decision of the Supreme Court itself. Kuram, Ekufu, JSC, Adinyira, Doche, Bafoboni, Badebe, Puaman, a full complement, a very strong panel of the Supreme Court in the case of Benjamin Komlakbodo and the Attorney General. And in that case, they were very clear. I mean, I have a
This is 20 what?
This case was decided in 2019.
Recently, so
very
who was
recent.
on the, this was under Sophia Akufu as
Yes,
CJ.
so Sophia
Did she
Akufu
sit on this?
She was presiding over the matter.
So there's Adinyira, Bafoboni, Gabriel Puaman, and who else?
Puaman, Agnes Doji, JSC, Justice Badegbe, all these very, very respectable justices of the Supreme Court in Bodo. And in this case, they were very clear. They held that treasury bills are part of, are regulated under Article 1815.
Really?
Sorry, yes, under Article 1813.
I'll
Yes,
take
they were
a
very
breather
clear.
and ask you to prove that when we come back.
Sure.
So now my guest is saying that the Supreme Court has already, based on its previous judgment, shown that treasury bills are part of government borrowing under Article 181. And therefore, this is a very straightforward matter. We'll come back to that with other issues. Stay with us. Government depends a lot on treasury bills for its finance. In the past few days, it's been looking for a lot of money. I'm told every week they get an average of 5 billion cedis from the treasury bill market. My guess, if it succeeds with this interlocutory injunction, would mean that the government cannot raise any additional funding or financing unless or until the substantive matter of February is determined. You're telling me that there's legal precedent to prove that your view that T-bills are actually government borrowing that requires parliamentary approval is clear.
Yeah, it's quite clear. And also just to emphasize the point that what we are seeking to do with the interlocutory injunction is not to prevent the government from raising new T-bills. We are saying they can borrow to the extent that they go and obtain parliamentary approval.
So if government wants to get any other money, starting from, when did you file this interlocutory injunction?
11th November.
I see. So basically that from that time, government should not go to the market unless it goes to parliament.
Exactly.
And parliament is not sitting.
Yes, but parliament is not sitting, but that's just a matter of convening. They can convene, and I know they will convene, I'm sure.
I'm sure they're convincing this to go.
Yes.
If they want any additional finances, go to parliament.
Yes, they should go to parliament, and it's really...
Does your
really
case affect previous borrowing they've done from the T-bill market?
No. So we could have. So the Supreme Court operates in a way that they give you what you ask for. Like I mentioned, when you ask for the declaration, you can ask for consequential orders.
Yes.
I did not ask for any consequential order to invalidate all the T-bills and domestic debt securities which have been issued prior to now. Because look, take for example the pensions industry. The pensions industry, by their regulations, are allowed to invest 75% of their assets under management in government securities. When it comes to other types of issuers, they are limited. So they can have like a 10% issuer limit for other corporates. But when it comes to government of Ghana, they have as much as 75% allocation.
Okay.
When you go to the collective investment schemes, our mutual funds and unit trusts, they have as much as 30% that they can allocate to the government. So if you ask for such an order, the consequences for our economy will be very dire.
So you do not go back. You're saying
yes,
that
I'm not going back.
You are
just looking forward. let's solve
Give
the
me the
problem that is
legal
coming.
authority that makes you believe that T-bills are clearly government borrowing.
Great. So this is Sufaya Kufu JSC speaking in the Kudo case. She says, now really, this case was looking at what is revenue for the purpose of the District Assembly Common Fund. How much of revenue must be allocated to the District Assembly's Common Fund?
Right.
And the Supreme Court was trying to exclude loans from revenue, because clearly loans are not revenue.
Okay.
So they said, our holding above is in respect of loans contracted within the purview of Article 181 by or under an authority of an Act of Parliament for the purposes of a particular identified project or program, and does not exclude any loan that is contracted to fund the national budget in general terms, such as government treasury bills and bonds, which are issued to raise money to finance regular government activities. So they are very clear.
The government treasury bills and bonds are loans.
They are loans
under 181.
and they are under 181.
And it's not the same as revenue.
Yes, and it's not revenue.
Because the case was looking at revenue.
At what is revenue. So
for you, it's if it's such a straightforward matter, why has nothing happened since February when you filed the original case?
So for me, I think a lot of instances when politicians cry about our constitution, we've given too much power, we have an executive president, they are really creating escape routes for themselves, because our constitution is very clear. And if our constitution and our laws are enforced, we wouldn't be where we are today. The constitution is very clear on what are regulated.
Okay.
So if you have a situation where the constitution says where there's a deviation, come to the Supreme Court and ask for an order. I think there's a situation where there's an abuse, because in the current framework that we have it, when you have a case that an act is going on that is unconstitutional, you go and file your claim at the Supreme Court. The Supreme Court will wait for the Attorney General to file his response before it will now say, okay, we have both sides. Now file a memorandum of issues, which will then enable the Supreme Court to sit on the matter, which means that the Attorney General can control how cases go by refusing or neglecting to file his response, because once he has not filed his response,
has to wait for the response.
Exactly.
The Supreme Court
will say, oh, the Attorney General has not filed, and so we have to wait. Meanwhile, if you take a normal criminal action, when a person is accused of committing a crime, immediately, at least within 48 hours, the person must be brought before court. You have a situation where the fundamental law of the land, the Constitution, is breached, and a situation where the person who is likely to have breached it can control how the case should go. I can ask you, if the person who controls rain or controls the weather sells umbrellas, do you think we will not have a rainy day? That's the situation that we have. Failed in February, up to date, the Attorney General has not filed a response.
Hasn't the court in the past sort of, because I know there are some cases where the court will say, look, if you don't file, we're going to determine the matter without you.
It's really difficult, because the court must now empanel. And it's easier to be done in applications than in the substantive matter. So for instance, if you look at all these recent injunction matters that we've had, with the LGBTQ bill, with the speaker and the vacation of seats and things, the substantive cases would usually be determined later than the applications. So that is why we then went ahead now, because our hands have been forced to go ahead now to file the injunction. But guess what? In all these other cases we are talking about, in the case, the LGBTQ case, for instance, when the government went when someone went and filed an injunction application to prevent the bill from being served on the government, in the case of the speaker and the vacation of the seats, you saw how the government made noise about how we are law-abiding, and if you are law-abiding, once an injunction application has been served on you, your hands must be stayed.
So basically, if the AG is dealing with the same principle, they need to move quickly on this.
Then if the AG is dealing with the same principle, since I filed the suit on 11th November, there wouldn't have been further T-bill issuances. But guess what? That Friday there was an issuance, even though they've been served. Last week Friday there was an issuance where they raised the 6 billion. They were looking to raise 6.8 billion, and they got the 5 billion that they got. They have issued a statement which indicates their further intention next week. I mean, this Friday, to raise another 6 billion.
In complete disregard for your suit.
Yes, they're acting as if no injunction application had been filed. If the tables were turned, you'll see how they'll be screaming from the rooftops.
Is it because they perceive this as if we don't raise the money, government will shut down? Because as you know, the government has been shut off international capital markets. Government revenue is not enough to meet its expenditure projections. it cannot borrow money from anywhere except the treasury bill market. So if your injunction succeeds, it could be construed to mean you're basically asking for a shutdown of government.
No, it's not asking for a shutdown. I mean, it comes back to the question of looking at our revenue and looking at our expenditure. Why are we spending so much more than our revenue? We fail to realize that when we spend much more than our revenue, that's a recipe for inflation. That is a recipe for the high interest rate environment that we are witnessing now. Because why are we doing that? The government can rationalize. And look, when you look at all the reports, when you look at the IMF, when you look at the World Bank, we go and look at the report that the IMF and the World Bank issued in 2021. They expect fiscal consolidation. And that fiscal consolidation means that we must be moving in a way where our debt is reducing, our expenditure is reducing, okay, and we are able to now get to a place where we can get a primary surplus, or we can, we can at least match our revenues with our expenditure. We declared a moratorium or stopped servicing our debt in 2022. Just look at the figure of our debt as at that 2022, and look at the figure that we have now.
It's much higher.
It's much higher. So obviously, even with the restructuring and things that have happened, our debt is still accumulating at an alarming rate. And look, if you think about the obligations that are coming, just speak to any financial advisor. The obligations that are on the government from 2025, 2026, 2027, 2028 are so huge.
So you think that if we continue borrowing the way we are going, whoever becomes the next president, finance minister, will have a big challenge paying for anything?
They will have a huge challenge. Look, we would have a crisis on our hands. If we are lucky, we will not have a balance of payments crisis, but we may very well have a balance of payments crisis. Because remember, and again, when you look at the charts, you will see the framework for our foreign receipts and our foreign payments. And that determines how much we'll be able to pay. And if you look at all the foreign payments that are due, and we know we don't have access to international capital markets, our cocoa is performing poorly. If you look at the data, you realize how much the cocoa through the syndicated loan and the export proceeds was contributing. Now we don't have that. We are relying heavily on gold. And that exposes us to commodity risk, because right now gold prices are high. There's no guarantee that gold prices will be high tomorrow. So when gold prices drop tomorrow, that will be another shock to the economy. And so we are really living on the edge. And the question is not really a matter of if you say government should get a parliamentary approval, you are blocking government's access to borrow, because borrowing is not a right. Borrowing must be done responsibly. And everybody, look, I was telling you this, everybody should just look at the Fitch reports that were coming up from 2021. March 2021, Fitch issued a report on Ghana. November 2021, Fitch issued a report on Ghana. January 2022, Fitch was the first rating agency to downgrade us. If you look at all these...
In January?
Yes. If you look at all these reports, you realize that Fitch had been predicting this situation that we experienced in 2022, that we are borrowing too much, we don't have enough. If there's a situation where we lose access to the international capital markets, we'll be in trouble. And guess what? We lost access to the international capital markets in 2021. The government has been claiming we lost access in 2022. It's false. Fitch has acknowledged it. Look at the IMF report. The IMF report, both the first report in 2023 and 2024, all assert that we lost access to the international capital markets in 2021, because in the latter part of 2021, the government wanted to issue social bonds. And market conditions were not favorable. So we have a big problem on our hands.
So we are waiting to see if the Attorney General, of course, this is not ex parte, right?
No, it's not ex parte.
So this is on notice. So you're expecting the AG to file?
I'm expecting the AG to file. The way the AG is acting, it looks like there's no intention to file, and so we are really considering how we can escalate, including I'm citing the Minister for Contempt, and I think by tomorrow we may have done that, to cite the Minister for Contempt. And you know, I know that the Supreme Court will relish an opportunity like this. Justice Tokonu, the CJ, she has a commercial law background. She was
so you think she will understand
judge.
this?
Yes, I know that she will deal with the matters quite superbly.
We'll see. We'll wait to see how that's good. Thank you very much, Jonathan Amabele, for your time and for this advocacy. Quite interesting. So bringing finance, public finance, and economic management into the legal framework. Very interesting and refreshing indeed. Thanks for watching. We'll update you on what happens in this space. As we know, government continues borrowing, and they did $5 billion I think, last week. We don't know what they'll try and get next week. If this matter gets to be heard, it will be a very interesting time for public financing in Ghana. We'll see you next time. Bye-bye.